Hi, it's Mike DelSignore. In today's video, I want to talk about a couple of cases that I had in Haverhill District Court where our clients were found not guilty. So one of the keys to having a client found not guilty is to really focus on what the client does right. In a lot of cases on the field sobriety test, you're going to see in the report things like miss heel to toe, fails to take the appropriate number of steps, steps off the line, unsteady on their feet. But I know the office's training. I have the training manuals, and I know there's a lot of things that people do right that aren't put in those police reports. So during cross-examination in both of these cases that I had, my focus was on emphasizing the things that the both clients did right in the field test, and those things to be gained there. In other words, a client who doesn't start the test too soon, who maintains balance in the instruction stance, those things are inconsistent with the office's opinion that the person's impaired. For example, even in many reports, you'll see that the person started too soon. For example, it's very common in police reports. But typically an officer will agree on cross-examination that after the person started, they got back in the stance and stood there for the duration of the instructions. So that's not a lost point. In other words, we can get that point back by saying, well, you know what, they started too soon. But once you had them in this stance, they stood there, way you told them to, awkward way to stand, heel to toe, for the full 30 seconds. Many times the one-leg stand, it can be ambiguous how long the person had their foot up. A lot of times they'll say put the foot down. In one of the cases I had from Haverhill, the officer said he stopped the exercise for safety reasons. That wasn't mentioned in the police report. So I was able to question the officer about his report, saying, well, this report was made close in time to the incident. It's true, complete, and accurate. You put all the important details, and then I usually try to pick out a small detail in the report that the officer put in. You know, you put in this detail, but you left out a major factor that the person couldn't maintain balance, and you had to stop the test for safety. That's something that would generally make the report when you put all these other factors in the report that aren't quite as important as that. That's sort of a major indicator. So the officer, acknowledged that, and I was able to argue across that, it really couldn't have been stopped for safety. Otherwise, that would have been in the police report. There was other things that weren't in the report in the case, and sometimes it comes up where the officer is basically being led by the DA. So watch when it happens. And I'm always looking for this. Does it really come from the officer? Is it more from the DA? So sometimes an officer will say that the person's unsteady getting out of the car. And that was the case in one of my trials in Haverhill. But it was basically a leading question from the DA. How did they appear going out of the car? And the officer kind of feels like they have to say, oh, unsteady there. So watch out for that, and we see that, I see that often where the answer isn't really coming from the officer, but from the DA. So leading questions, while sometimes the judge will let it in and the jury can hear it, it still goes to credibility. Is this really coming from the officer? Is this really the officer's memory? It goes to the integrity of the opinion and whether there's enough for proof beyond a reasonable doubt. So keep in mind that an OUI charge is a very difficult charge to prove in any court. Haverhill District Court is a court I've had a lot of success in. It's a high standard burden of proof. Case has to be proven to an abiding conviction to a near moral certainty. The other case I had where the client was found not guilty was an accident. An accident case can be a difficult case. It's a tough way to start when there is evidence of bad driving. But in this case, I was able to really show that the field tests were inconsistent with impairment. The person did have a plausible explanation for the accident, and I was able to argue that explanation should be credited, or at least give you pause, hesitation, reasonable doubt, because of the client's performance on the field sobriety test. So if you need help with an OUI in Haverhill District Court or any court, feel free to call me. My name is Mike DelSignore. I help people with OUI cases every day. Call, text anytime, 781-686-5924.